Thank you for joining us today on the Ask Andrew Show, Canada's first live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Greater Toronto Area family law firm, Feldstein Family Law Group. Today, our special guest is Daphna Schwartz. She's a senior lawyer here at Feldstein Family Law Group. She has a wide range of experience in family law and is a trained collaborative family law lawyer. Today, we're going to discuss the benefits of collaborative family law. Welcome to the show, Daphna.
Thank you for having me.
So the first question I frequently hear from people when you mention collaborative family law is, what is it? So what do you think of when you think of collaborative family law? What is it?
So collaborative family law is an alternative dispute resolution way of dealing with negotiations and settlement. So it's a process whereby the parties are kept out of court and they agree to not engage in a court process. So everything is done with counsel. Now, counsel have to be collaboratively trained in order to engage in the collaborative family process.
Okay, now I find that an important part of it is also explaining what is the collaborative process, because it's very different than a traditional case. And what would you consider to be the hallmarks of a collaborative case?
So the collaborative practice is a voluntary process, and it's whereby parties want to engage in a process where there's going to be respectful communication. It's going to be an open process, and parties, what they do is they'll sign what's called a participation agreement, where they agree to participate in this process together without this threat of litigation. So both parties are going to agree that they're not going to litigate and everything's going to be done with counsel, engage in what's called settlement meetings, and the parties basically control the process themselves. So they are the ones who determine what issues are going to be discussed, how they're going to be discussed, when they're going to be discussed with counsel, and they set an agenda how they're going to deal with each issue and hopefully move towards a resolution of each issue.
In my experience with collaborative family law, one of the important pieces of the participation agreement is that neither party can proceed to court without giving written notice, usually for a period of something like 30 days. And what's very important to people in the collaborative process is that they actually cannot use the same lawyer to go to court. So if a lawyer has signed that participation agreement, usually the agreement would reflect that not just the lawyer, but their entire firm is prohibited from acting to take the case to court. And I believe that that's there as an impediment to make people realize it's expensive to start over again. Now, would you agree that's an important piece of collaborative family law?
Yes, and it's not just also they don't start over. I think when that's there, it then allows the parties, I think they're in the mind frame that they've engaged in this, and it helps them to want to actually negotiate and settle. Because they don't, number one, want to start the process again, and they don't want to have to find a new lawyer. So I think that is helpful in having them in the mind frame of, dealing with the issues and being engaged in the process.
Now, would you agree with me as well that the style of negotiation in a collaborative case, in terms of the way the lawyers meet and the way the meetings are conducted, are different than in a traditional case when people are trying to resolve their matter?
Definitely. What happens is, and that's where the training comes in. So you're trained to deal in a cooperative way. So the whole process is to work cooperatively together, to deal with each issue together, to discuss each issue. Whereas if you're involved in a litigation, you're not discussing much. It's the judge that is, basically asking questions or giving opinions and not allowing the parties to be as cooperative as they are in the collaborative process.
Now, I would also say in the collaborative process, where I would look at having a settlement meeting, would be different than what people would do in a traditional case. For example, in a collaborative meeting, you typically have an agenda that is circulated prior to the meeting to the lawyers and to the parties. And there's usually one side will do progress notes at the end of the meeting that actually goes out to the lawyers and the parties. Would you agree with that?
Yes, and I think that's a good thing. So what happens is in the collaborative process, everything is done and all the parties are engaged with the lawyers. So if there are notes and there's an email that goes back and forth, each party is copied on the email. So whereas it's just in traditional method, it's just the lawyers that are, sending letters back and forth or emailing each other, although a client will likely be copied on it. They're not as involved in how it's happening.
Okay. Now, what would you say is the greatest advantage of collaborative family law?
So I think there's a number of them. One of, as I said before, to reiterate, one of the greatest advantages is that the parties have more control over the process and the outcome. So they're the ones that are determining what the agenda is going to be, what issues are going to be discussed, when they're going to be discussed, and to discuss, different ways of settling these issues. Of course, within all the legal aspects. In a court process, you don't have that control. It's the judge that's going to be determining the process for you, or the court system that's going to be determining that process for you. It should be less time consuming. You may get through one issue, two issues, three issues at each meeting, and you determine what the next steps are going to be or when the next meeting is going to be. In a litigation process, you have to go with the timelines of the court. And it could be, 1, 2, 3, 4 months until you get into your next court date. So that's also a big one of the pros to or an advantage through the collaborative process.
Now, it's interesting because at the same time I asked you that question and you started to answer it, we got a question asking, what is the difference between the traditional divorce and collaborative? And I think when you were highlighting the advantages there, I think you really, for the most part, answered that question from one of our viewers. Now, what would you say is the greatest disadvantage of the collaborative family law process?
Well, one of them, as we've talked about, is that if it does fall apart, one of the disadvantages is that you will need to find another lawyer to assist you if you do need to litigate. So that's one of the big disadvantage. I think as well, cost-wise, it should be more cost-effective. However, part of the collaborative process is sometimes having what we call different team members or professionals to assist. So we may have, for example, a social worker or psychologist that can assist with child-related issues, or what we call a financial professional that can assist the parties with drafting financial statements or looking at the financial issues. It could become more expensive if there's too many professionals involved. However, it should still outweigh the cost of going to litigation. You go to if you're involved in litigation, it could be at court all day, and that could cost you much more money than just, being involved in the collaborative process and having a day where the hours may be the same during the day, but you may have less of those days as you would if you were in litigation.
I think what you're really saying, and some people don't appreciate, is when you go to court, depending on the courthouse you're going to, you may have a court appearance scheduled for 9:30 and you find out that you're one of 5 matters on a list at 9:30, and you may be sitting there for 4 hours to wait and see a judge for 30 minutes. And if there's nothing to negotiate, you're paying your lawyer to drive to court, you're paying your lawyer to sit, you're paying your lawyer to drive back from court. You're spending a lot of money on wasted time. Whereas in the collaborative process, you're actually using the time to work on the file and move forward with it. I see we have another question. Is collaborative family law with just, I'm trying to make out what the question says, I think it's saying with one lawyer, or do there have to be 2 lawyers?
So there has to be 2 lawyers. So each party needs to have their own lawyer representing them. So you can't be engaged in the collaborative process unrepresented. Part of the process, you have to have what's called a collaboratively trained lawyer. So lawyers who are collaboratively trained, they have, it's a process whereby there's essentially 2 levels that you take. It's called level 1 training, level 2 training. So you must complete both levels, which basically teaches you the skills necessary to be a collaboratively trained lawyer. So each party must have a lawyer to assist them in engaging in the process. You can't do it unrepresented. Whereas in litigation, you could be an unrepresented party.
Now, I should add that both Daphna and I are trained collaborative family law lawyers. There are other trained collaborative family law lawyers at our firm. And if you wish to discuss a collaborative family law case with one of us and you want to book a free consultation, you can contact us by phone, 905-415-1636. Or in the alternative, you can visit our website at separation.ca and use one of our many contact us links, and we'll be happy to call you back. Now, when we just spoke earlier about the issue of pros and cons. Who can practice collaborative family law?
So I'll reiterate again. So you need to be, the lawyer has to be trained in order to practice collaborative family law. There's 2 levels of training that a lawyer needs to pass. There's different places that the lawyers can do the training. And once you've passed these levels, you're then able to, you then learn the skills necessary and then the tools necessary to engage to assist clients in the collaborative family process.
Now, how do you determine if someone is a good or bad fit for collaborative family law?
So I think it's important that, if the party, I get clients who come to me in 2 ways. Either they're asking about this process, they've read about it, they've heard about it, or their spouse or partner has gone to a lawyer who suggested it. Either way, they have to be very open to cooperating, to engaging in respectful communication. If parties are not able to communicate effectively or sit down and be able to cooperate with each other, it's really not going to be a very good process for them. So that's key. And parties need to be able to focus on solutions and what's important for them to resolve issues. If they're stuck on certain positions or they're angry about certain things, they need to overcome that or the process may not work.
Okay, now I'm going to take it one step further because I may look at things differently than other lawyers do, and common among lawyers that we have different viewpoints, but I also look at a good fit in terms of power. And in family law, I frequently view cases as power, and it's people will fight about who has power. There may have been one person who had the power in the marriage, and now that they're separated, the other person is trying to take back some of the power. And there may be power over money, and there may be power over the kids. And I find that collaborative family law can create a problem when one person has control over the money and control over the documentary disclosure. So you need to be very careful about taking on a collaborative case when someone is self-employed. Now, I know a lot of collaborative family law lawyers will disagree with me on that, but you don't want to get involved in a case when the disclosure will not be forthcoming. And if you're about to enter into it and the other side is self-employed, you need to consider whether or not you're comfortable that the disclosure will be forthcoming. Because if it won't be, it's not a good fit. And what type of disclosure? Well, when you're going through a divorce or separation, all your financial records are fair game and will have to be produced. So you need to be careful about that. And what you were saying before, Daphna, about people being able to get along, is I've also seen cases where somebody goes into the collaborative process and they drag it along. And people spend $10,000, $20,000, and then they feel that they vested so much in this process that they don't want to walk away, and they sign a really, really, really bad deal. And you have to have that discussion with your client to see, is their former spouse the kind of person who will try and play that game? Because if they are, you don't want to be part of the collaborative process. I mean, do you agree with that kind of view?
So full disclosure and transparency is key. If there's no full disclosure, the process is not going to work. Even with the traditional method, that is to say. That being said, it could work. There are financial professionals that could assist or to have a valuation done or determining what someone's income is. But agreed, if someone comes in saying, on my income tax return, I only earn $10,000 and that's all it is, it may not work. And that being said, power imbalance is issue. If there's been a big power imbalance in the marriage or in the relationship, it may not work. So those things need to be looked at to determine if there is a power imbalance. Again, negotiations may not work if there's not fair game.
Okay, now we had another question that came in, and it was, does collaborative family law work for people with kids and or without kids?
So it works in both ways. If children are involved, as I think I said earlier, a parenting schedule and a parenting plan are things that can be looked at. There may be a social worker or someone that can be involved. And I think the collaborative process, if people have children, is a wonderful process, because if they can learn or they can cooperate with each other and negotiate to a resolution, this will help them in the long run to co-parent and communicate effectively ongoing. Without children, the same thing. If we're looking at just financial issues, works the same way. Counsel will look at financial disclosure and determine property issues and if there's support issues. And again, we may need to bring in a financial person to help out if the counsel are not able to agree or with the parties as to what the numbers should look like. Then you can get some professionals to help with that as well. So it works in both scenarios.
Well, one of the things I will do in collaborative family law is proposed is I have a discussion with the other lawyer to try and get a feel for disclosure if I'm against the self-employed person. And if that's the case, I try to get an agreement contemporaneously drafted at the same time as a participation agreement for that joint family business valuator, that team member to join the process and to know what disclosure is going to be given, because I want to make sure I'm not going to be met with a brick wall later on. I find that helps. And I see we had another question, which is, can a children's lawyer be involved in the collaborative process?
Yeah, so a children's lawyer definitely would be a professional. Great, as in any process, a children's lawyer, that's determined by the parties and by counsel. So if it's determined that a children's lawyer or someone to assist the parties or the children in determining what the children, their views and preferences, assuming they're at a certain age, that a children's lawyer would be helpful. You're talking a little bit older, possibly 12, 13, 14. There are individuals, who engage as children's lawyers that the parties can agree to retain, that can speak with the children, provide feedback to the parents, to the couple, to help them in determining what a parenting schedule should look like.
So, for example, they would hire a social worker who could meet with the parties and meet with the children if need be to help formulate a parenting schedule. But it wouldn't be somebody who, in quotes, would be from the office of the children's lawyer, because that person could only be retained by order of the court. And since you're in collaborative family law, it's not before the court and you wouldn't have a court order.
Correct. It could be the parties would agree to that and they would retain someone privately who engages in this work privately for families that require that type of assistance for children. And there are individuals out there who do these things.
And I see another question came in, which is, are financially complex cases appropriate for collaborative family law? And the answer, like anything else in life, is maybe. If you're going to get the disclosure and if you're going to get joint valuations done, then collaborative family law can be appropriate. However, if you perceive that there's going to be any games played by the owner of the business with respect to the disclosure or the valuing of the business, then it may not be appropriate. Sometimes what, as a lawyer, I may say is, I'm not prepared to sign the participation agreement, but I like the collaborative process in terms of the style of the meetings and having an agenda and trying to look at the case from a holistic approach. And let's approach the case that way, but without signing the participation agreement. That's another solution for complex cases that you want to avoid the need for going to court. One of the questions I have from people sometimes is, how do I know somebody is the right fit for collaborative family law? So as an example, I've been asked, should I go to a lawyer that says, all I do is collaborative family law? Or should I go to a lawyer that does collaborative and does litigation as well?
So I think that when you're going to a lawyer who practices collaborative family law, I think it's important that they engage in all areas of law, whether it's engaging
in all areas of family law, or practicing areas, we should say, in areas of family law, whether it's a traditional method, whether they've been involved in mediations, whether they're doing collaborative. A lawyer then gains experience in different areas and learns different skills. And I think that if you don't engage in litigation, you really don't know the trends in the law and what judges are saying and what may happen, that you can advise a client to say, look, if this process falls apart or it's not working or you can't settle and you end up in litigation, this is what may happen. So it's important, I think, that when you're speaking with a lawyer, that the lawyer that you're going to retain who for collaborative law as well engages in different areas of family law as well. And that really gets to a point when I've had a client come into me and they've done a lot of educational research themselves on the internet, and they point to a statute and they say, well, the statute says ABC, and I usually point to them, you notice the word in that statute says may and not shall, and that means it's discretionary. And one of the things as a lawyer that regularly goes to court that you get a feeling from is what judges do in those statutes that are may. And family law is full of maybes. And if you're not going to court, Daphna's point of knowing the trends is the gut feel that in my case, almost 25 years of experience gives me as to what the courts will say. And it's frustrating when I've done a collaborative case and I'm against a lawyer that hasn't been in court in 6 or 7 or 10 years because all they do is collaborative family law and they say something. And I know from my experience, no judges are doing that. There's zero possibility. And it moves people in the wrong direction because the other side says, well, my lawyer's saying this and the statute says may. So you got to realize that if you want to know practically speaking what's happening, you need to go to court. And lawyers will refer to what a judge may do, not because we're hoping to go to court, but because that's our yardstick for what we perceive would happen if we did go to court, and we use that as a measurement to settle. And one of the things in collaborative family law that's encouraged is trading off rights and interests. I could take more support for less time. I can trade off my house for some support. So there's things you do that are supposed to be more creative in family law in order to fashion resolution, but they're supposed to be done with proper trade-offs, and understanding what the yardstick is really important. Now, we've had 2 more questions come in since our last little exchange. First one is, if I don't want to use a collaborative process, will this make me look bad at court or to an arbitrator? And I think that's a really easy answer. The answer is no. You don't feel comfortable with the process, don't opt in. No one's going to hold it against you for not opting in. The second question we had come in is, my family law matter includes property claims with my in-laws. Can collaborative family law still work if there are third parties? It's a great question because I haven't used collaborative family law for third parties. Have you, Daphna?
No, I have not. And I assume it would work, of course, but the third parties, if there's disclosure issues, for example, the third parties would have to agree that they're going to be providing certain documents if necessary, or their involvement. The only way to do that, of course, if in litigation, is to get a court order for that. So as this is a voluntary process, I suppose it could work, but there would have to be agreements that this third parties would be able to provide whatever's necessary in order to help the parties settle whatever issues related to the third parties.
I actually think the third parties would have to sign the participation agreement and be represented by counsel. But it's a great question. I'm not sure the answer. I see we have another question. Is collaborative family law limited to Ontario? No, it actually started in the US and moved to Canada. And it's, I believe, across most jurisdictions in North America do have lawyers that are trained collaborative lawyers. The other question I've had is, sometimes I have clients come in and they've signed up agreements through the collaborative process that they view now as being unfair 2 years or 3 years after they signed the agreement. And when I read the agreement, sometimes they really are unfair. And it means just because you opt in this process, don't think that the agreement will necessarily be fair. Don't think it means you're supposed to give up your rights, because the courts have said you still have to have an agreement that is in accordance with the law. It's just a matter of trading things off. Now, one of the other areas I get to is a situation of, should people be hiring 2 lawyers that are in the same physical office because it's collaborative instead of litigation or the traditional method? And what's your thoughts on that?
Well, if they're in the same office, at the end of the day, the collaborative process is focusing on solutions that, to consider both parties' interests, but you still have to take into account your client's legal rights at the end of the day. And with that being said, if you're 2 lawyers, there would appear to be a conflict of interest if you're in the same office or working in the same office. So my answer to that would probably be no. You should look for a lawyer who's still independent and not related to that office, because there may be a conflict of interest.
Well, it's not just, to me, there's maybe a conflict of interest, because whenever I'm drafting an agreement, I like to think that my agreements will be enforceable by a court if someone challenges it. I also think, both as a divorced individual and as a lawyer practicing in this area, when I'm divorced and I have my separation agreement, I want to know that I can count on my separation agreement will be valid, because I want to be able to plan my life accordingly. And if you do something to jeopardize the validity of the agreement, it's like there's a cloud hanging over your head now. And I would think if 2 lawyers are in the same physical space, even if they're not part of the same firm, you're giving somebody the ability to subsequently argue that this agreement was not negotiated in a proper fashion. And in fact, the Supreme Court of Canada, in the decision that dealt with releases of spousal support, talks about the fact the agreement has to be negotiated in an unimpeachable fashion. So if you've obtained a release of spousal support, as an example, and the two lawyers are in the same office, was that agreement negotiated in unimpeachable fashion? Maybe not. So why would you want to take that chance? Why would you want to take that risk? So I think if two lawyers are ever saying to you, well, hire someone else in my physical space, they're a different law firm than me, I think you have to look at that very critically and think to yourself whether or not that's something you want to do, because in my mind, it's going to put that agreement at risk. And if I had a client walk into my office who asked to set aside that agreement, I would probably recommend going for it if I thought it was worthwhile in terms of being able to do better. Now, I see we got another question that came in. What can I do when participating in the collaborative process to save money, time, and move things forward?
Well, the short answer to that is you need to cooperate. So to move it forward and to make it less costly is to make sure all your financial disclosure is ready and provided, that things don't have to keep being asked for, being engaged, cooperating with each other and moving forward when you're having these settlement meetings. Of course, there's things to discuss. There may be things that you need to clear and get out of the way, and that's completely appropriate. But that moves things more forward, is cooperating, having an open mind, being respectful of each other, and wanting to engage really in resolving these issues. And that will keep things moving faster and keep it less costly. Then things are taking a long time. That's where the costs start to increase.
And costs increase when people dig in their heels over sometimes what may seem to lawyers as really small issues. It may seem important to the litigant or the party, but you really do need to look at the big picture and work on what will the parenting be and have a pretty good idea of where it's going to be. And if the professionals recommend getting a team member like a social worker to help, take them up on that offer. Make yourself available. Don't make people chase you down to get the disclosure. So there has to be umpteen letters dealing with it. Get the disclosure, get to the table, get to negotiations. If there's a business involved, hire the joint valuator who will be a team member to help with that. It can help to have that team member be a financial planner or an accountant who will help with the net family property statement to put it together for both parties. All of these things can be good things to move it forward. But at the end of the day, it's being reasonable, and hopefully both sides are being reasonable will get you towards a solution much faster. Now, we may have said this before, but I think it's an important question that needs to be asked, which is what happens if you go into collaborative family law and it doesn't work?
So if it doesn't work, again, it's a voluntary process. If it doesn't work, one party has to provide notice to the other that the process is not working for them and that they want to withdraw voluntarily from the process. Once that happens, there's different ways to deal with it. If they're still involved in the process, the parties may need the assistance of a mediator, and they could agree that they'll go off to mediation, which is they're hiring a mediator who's usually a senior lawyer, and they're going to pay the cost of the mediator, and they will, instead of, again, the parties and the lawyers controlling the process, they will assist the parties in controlling a process to assist them in coming to a resolution of whatever issues it is that they can't settle. So that may be of assistance. If that is not an option, then the parties need to withdraw. The only option for them may be litigation. If that is the case, then they have to find other lawyers to represent them in the litigation, as under the participation agreement, you can't engage the same lawyer who was your collaborative family law lawyer for the litigation process.
Okay, well, I want to say thank you to you, Ms. Schwartz, because time is up for the show. Thank you for appearing, and it's been a pleasure having you. For anyone interested in learning more about our firm or Daphna's work, you can visit our website at separation.ca. The next Ask Andrew show is on January 16th, 2019 at 1 o'clock. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.